This is about the Yazidis, Christian minorities, and other victims of international crimes, and their right to access of international justice. The failure, refusal, or neglect to refer the situations in Syria and Iraq and ISIS, also known as Daesh, to the International Criminal Court, or an established competent international criminal or penal tribunal, deprive and derogate the affected populations, victims of the right to a remedy and reparation for victims of gross violations of international human rights law and serious violations of international humanitarian law, pursuant to the United Nations General Assembly Resolution 60/147 of 16 December 2005. The right of equality before the law and equal protection of the law that provides the right to access to international justice in accordance with Article 7 of the Universal Declaration of Human Rights, and other treaties and rights instruments, that is, international treaties to uphold these rights, including the International Covenant on Civil and Political Rights, ICCPR, and the International Covenant on Social, Economic, and Cultural Rights, ICESCR. For example, Syria ratified this ICCPR on March 23, 1976, and the ICESCR on January 3, 1976. It also deprives these victims or survivors, affected populations, of the principle of primacy of international law in a competent international tribunal established in accordance with the proper international standards, which provide all the guarantees of fairness, justice, and even-handedness in full conformity with internationally recognized human rights instruments established in accordance with the proper international standards. Furthermore, such failure, refusal, or neglect to refer the situations in Syria and Iraq and ISIS and Daesh to the ICC or an established competent international tribunal prolong the conflicts and impunities and aggravates the atrocity crimes. For example, the Syrian war or the Syrian conflict, which began on the 15th of March 2011, is presently ongoing. It has been going on for the past 5 years, 8 months, 2 weeks, and days. The right of access to justice at the international levels constitutes a basic cornerstone of the international protection of human rights and conforms a true right to the law. It amounts lato sensu, in broad sense, to the right to the realization of justice. It comprises not only the formal access to a tribunal or judge, but also respect for the guarantees of due process of law, the right to a fair trial and to reparations, and the faithful execution of judgments. The right of international individual petition, together with the safeguard of the integrity of international jurisdiction, constitute the basic foundations of the emancipation of the individual. This is a domain that has undergone a remarkable development in recent years. It is humbly submitted that the right to access to international justice and the right of access to justice belong today to the domain of jus cogens, a peremptory realm. Without it, there can be no legal system at all. The protection of the human person in the most adverse circumstances has evolved amongst considerations of ordre public, the public order. Such recent evolution has been contributing the gradual expansion of the material content of use cogents. Furthermore, the very notion of victim, encompassing direct, indirect, and potential victims, has been the subject of a considerable international case law corpus. Victims have had their cause vindicated in situations of utmost adversity, if not defenselessness. For this present situation, the concentration is upon communities in situations of conflicts, internally displaced persons, individuals in infrahuman conditions of detention, and surviving victims of genocide or massacres. The Yazidis, Christian minorities, Muslim minorities, and other victims in those situations beforehand deserve and have the same right of access to international justice that was afforded to the victims of the Srebrenica genocide, to the victims of the Rwandan genocide, to the victims of all other mass atrocity crimes. And this will done through specialized tribunals in the ICTY and the ICTR. And there are also other victims of atrocity crimes that have had their cases heard before the International Criminal Court. For this purpose alone, such rights of victims of situations in Syria, Iraq, ISIS, Daesh, etc. deserve the same rights as that afforded to other victims of atrocity crimes that have already been tried or are being tried in competent and established international tribunals.